afternoon, Alex.
Good afternoon, Marco. How are you doing?
Yeah, very well up here in Costa Blanca. And yourself down in Marbella?
Yeah, all good down here on the Costa del Sol.
Sun's shining as usual.
The sun is shining, yes.
Yeah, it's been beautiful actually, hasn't it, for January?
Yeah.
Okay, so this is a live session with Alex Radford from Legal Services in Spain. And then Alex, from you?
Yeah, so my name is Alex Radford. I'm an English solicitor and Spanish lawyer. I've lived in Spain now for nearly 30 years, and we act for British clients buying, selling, inheriting property in Spain, and also doing business in Spain. Basically, back to the here today. We've talked about the benefits of a Spanish will. For the sake of a few €100, we charge online. It's €212 for a Spanish will. You can sign that in Spain, or you can sign it in your home country. It's got to be signed before a notary. It's got to be stamped with the apostille of The Hague if you sign it outside of Spain. If you sign it in Spain, then you sign it in front of a notary here, and they'll let the civil registry know that you've signed it. The civil registry will keep a record that you've signed a will in front of that notary. So upon death, you go along to the civil registry, and they'll confirm where and when the deceased signed a Spanish will. So it's a great system. Mm-hmm. Moving on then, apart from a Spanish will, which we've talked about the benefits of, the other document that people can sign is a power of attorney. So while I'm still here, I'm mobile and I've got my mental capacity, but I'm worried that maybe further down the line I might start to suffer from a degenerative illness that could impair my mental capacity. Let me put a power of attorney in place. And a power of attorney, I could sign that in favour of my wife or a trusted person. It has to be a trusted person. And basically, that power of attorney will allow them to govern my affairs. They can open bank accounts, they can close bank accounts, they can take money out of bank accounts, they can sell property, buy property, issue legal proceedings, a broad range of powers and faculties to carry out. Right. Now, when I die, that power of attorney dies with me, so it comes to an end. But until I die, that power of attorney continues to exist until I lose my mental capacity. And then when I lose my mental capacity, then you would go along, the person who has the power of attorney would basically have to apply to court and be appointed as a guardian so they could manage my affairs. And the fact that they've signed a power of attorney means that the court will look favourably on that applicant and probably 9 times out of 10 grant them the guardianship of that person, because that person has already indicated in a power of attorney that they want the applicant to court to look after their affairs.
Right. So really, with a power of attorney, you're recommending that to be the closest person to you, so the husband or wife, or a very close member of the family, and that power of attorney is just going to sit there until such time it's needed and protect that person for the future, just to make sure that they're covered in every angle, that that their affairs are going to be taken forward for them, looked after. And it's just something that should only really be taken up by somebody who thinks that they have an illness or a reason to do that.
Yeah, I mean, it's a good document to have. You never know what's around the corner. So I recommend powers of attorney to healthy people who have just purchased a property. Let's sign the Spanish will. Let's sign the power of attorney to each other. You could walk out the notary after the purchase of the property, get knocked down. Okay. Or 20 years time, you start to suffer a degenerative illness. That power of attorney is just it's another document that makes life easier for your family members to govern your affairs if you're unable to do so.
Yeah, and that's probably mainly because obviously foreign country rules are different, laws are different, and it just covers both parties. If it's a single person living on their own, then they would appoint the nearest closest person to them, a member of family. They don't have to live in they don't have to live in Spain to have this done.
No, they don't have to live in Spain. But what is very important, Marco, is that they do appoint someone who they trust. Mm-hmm. Without any reservations whatsoever, because you're giving the crown jewels to that person.
Yeah. So very good advice. The Spanish will, the power of attorney, both at the same time. You can take on that task and it's fairly simple, and it's quite reasonably that most people can afford to have this done. It's not an expensive job.
Exactly. So we would recommend that when someone buys a Spanish property, that they put in place the Spanish will and that power of attorney. The costs are set out on our website under our fees section. And another very useful document is a letter of wishes. So someone's moved to Spain, they live here, they might have a nice watch, might have some jewelry, ornaments in their house, a car, special items, and they want those special items. Sometimes don't even have to a value; it's just a sentimental value, and they want those items to go to a certain person, a certain loved individual. So in those situations, we would recommend a letter of wishes, and that document is essentially a letter where you set out that you've got X amount of items and you want to leave them to X person. Right. And we would keep that letter with the power of attorney and the Spanish will.
And that letter is because those items aren't listed within the will. It's an attachment. It's an annex to the will that makes life easier just to cover each and every item that you want to grant to somebody else.
Yeah, not normally in Spain. You would only really refer in the Spanish will. You'd only really refer to your big items, so a house, a car, bank account, shares, assets, bigger assets. If you rings, watches, items of sentimental value, we wouldn't normally include that in a Spanish will. And that's why we would recommend a letter of wishes to cover those circumstances.
Yeah, fair enough. In normal circumstances, that's the way you do it. So the package then is the letter of wishes, the power of attorney, and the Spanish will.
Yeah.
Remembering to make sure that the Spanish will is not claused out when a will abroad in another country is then updated, because that's a normal clause, to make sure that it doesn't delete the Spanish will. Yeah. And that then makes everyone a lot more comfortable living in a foreign environment and not being caught up with what complications can happen. And unfortunately, at the worst time when people really don't need complications and extra stress, makes that perfectly easy to deal with all of their affairs. So that's recommended. And that makes that makes it easy then for us to talk next time about what else do you recommend?
Yeah, well, as well as that, so we're talking about the here today. So here today, you can put those Spanish will, power of attorney, the letter of wishes in place, but also you can do other things. So, for example, you've got to think about when you pass away, how is the person you're leaving the assets to going to manage your affairs? So you should, in effect, I'd say, start sharing information about your property, about your assets with the trusted people, or prepare a letter of instructions. So I'd say, collate all the information about your assets, where they're located, where they're registered. Share that information with your trusted family members, so that they're aware of what to do when the time comes. Lots of us may have too many bank accounts. Close some of those bank accounts down. Start just putting your affairs in order. So I'd certainly recommend people living in Spain collate a list of assets, collate a list of important docs. So they've got one folder in one place with the Spanish wills in there, the power of attorney, letter of wishes, and say the deeds of the property, details of the bank accounts, and those that folder is ready, perhaps with a letter saying, look, maybe call Alex at Legal Services in Spain if you want, or call your other lawyer, call someone when the time comes, and they can talk you through the next steps. But in the meantime, here are the list of my assets, and that's really quite important, I'd say, Marco.
Yeah.
And then I mentioned earlier, whoever inherits the asset in Spain pays tax. Okay, so also there's a lot of people living in Spain and they're not married, and essentially, if they did get married, there are more allowances for spouses than non-spouses.
That used to be the case in the UK, didn't it, years ago?
Yes, yeah, absolutely. You had common law wife, and basically a common law wife or husband. It doesn't exist, and now we've got civil partnership. But in Spain, we have got what's known as the pareja de hecho, and we've also got we've got kind of civil civil ceremonies so people can get married. So if you are living in sin, so to speak, I'd certainly suggest that people look at those options because, again, someone would pay significantly more inheritance tax if they were unmarried compared to if they were married.
So they really got to sort that out. Yeah.
So, I mean, it is amazing.
Yeah.
We've spoken to clients who are moving to Spain, they're unmarried, prepared calculations for them on inheritance tax. And they go, wow. I said, look, if you get married or enter into a kind of form of civil partnership, then in effect, that inheritance tax liability disappears. And lo and behold, they come to Spain, they've got a ring on their finger, they've got married. So
there's always a reason. There's always a reason. It's
the most unromantic reason, Marco, but it is a reason. Yeah?
Okay. Is there any advice there, Alex, on having assets registered? Are you allowed to have your Spanish assets sort of in the name of the UK company, or any way that people can protect their assets from being taxed in Spain?
Yeah, I mean, that comes back to the ownership options. So when someone's looking at buying property, it's important to consider all ownership options, whether you buy it in the name of a limited company or you buy it in your own individual name. Generally speaking, unless it's multi-million euro villa, it's probably best to buy it in your own names, maybe along with the family members to mitigate inheritance tax. But each person's circumstances are different, so we would look at those individually. And rule of thumb, I'd say, if you're moving to Spain, as opposed to having a holiday home, definitely buy the property in your own name. Because, for example, if it's your main residence, you've been a resident in Spain for more than 3 years, as a tax resident, so you've declared tax in Spain on worldwide income and assets, and you're over the age of 65, there's no capital gains tax when you sell a property.
Right.
So if you'd bought a property and you put it in a limited company and you wanted to sell it, you'd pay capital gains tax. You'd pay corporation tax in Spain. Sorry. Whereas if you'd bought it in your own individual names and you over the age of 65, 3 years tax resident here, and it's your main residence, no capital gains tax at all. So that's why I think it's very important to discuss ownership options up front when considering a property purchase.
Great advice, Alex. And just to recap on this, obviously there's more to come in our next part, but people can get this advice from you personally. They can contact you directly either through the website, which obviously legalservicesinspain.com, or inheritingSpanishAssets.com. There's a contact us form there. Your phone number's on there, I've noticed, and your mobile number as well. So there's a direct contact there, and you cover the whole of Spain.
Yes.
And that can be talking obviously directly to you, but then people can make an appointment with a local office and actually get to meet somebody.
Yes, that's right. Yeah.
And do their documents that we've referred to get held in a strong room here in Spain?
No, when you sign a Spanish will, the notary holds on to the original signed version, and gives you the first authorized copy. And so in effect, the notary holds on to the original, and you've got a copy. So there's no need to kind of store those documents. And deeds, when we act for clients and property purchases, we always return the deeds to them. So the client would hold the original deeds.
Okay. And the letter of wishes?
The letter of wishes. So if someone instructed us to prepare powers of attorney for them and wills and the letter of wishes, and they wanted us to hold on to them for when the time comes, then to then contact their heirs and beneficiaries, we'd happy to do so. To do that, yeah.
Okay, that's it for this session, isn't it, Alex? And we've got more to talk on the subject next time.
Look forward to it.
I believe, yeah?
Look forward to it, Marco. Whereas if you put it in your own individual names, and over the age of 65, 2 years tax resident here, and it's your main residence, no capital gains tax at all. So that's why I think it's very important to discuss ownership options up front when